The ruling that rattled the world. Well, your world is about to change. The price of your coffee could change. The parts in your car could change. The way your data is handled could change. This is not because of a war or a financial crash. It is because of a court case. A single decision by the United States Supreme Court has quietly set in motion a series of events that will reshape the flow of goods-money ideas across the globe. This is a story about how a seemingly obscure legal principle can have profound, real-world consequences for everyone. The largest multinational corporation, the smallest consumer clicking ad to cart. The decision, handed down in 2024, officially ended a 40-year-old legal doctrine known as the Chevron deference. For decades, this rule guided how American laws were put into practice. It was a simple but powerful idea. When a law passed by Congress was ambiguous or silent on a specific detail, the government agency in charge of that area got to interpret the law. As long as their interpretation was reasonable, courts would defer to their expertise. This allowed agencies to adapt quickly to new technologies, emerging threats, changing economic conditions, creating a relatively stable and predictable regulatory environment for international trade. Now, that entire framework has been dismantled. The Supreme Court has declared that from this day forward, judges, not agency experts, will have the final say on what an unclear law means. It is a seismic shift. What was the Chevron rule? To understand the magnitude of this change, we must first grasp what the Chevron rule truly was. Imagine Congress writes a law in 1990 to ensure the safety of telecommunications devices. At the time, this meant landline phones, fax machines. But by 2025 it could mean smartphones, smartwatches, internet-connected home assistants. The law itself did not define these new technologies. Under Chevron, the FCC could interpret the old law to cover these new devices. This allowed for nimble governance, letting rules evolve alongside technology without needing Congress to pass a new law for every single innovation. This principle of deference was born from a 1984 Supreme Court case, Chevron USA, Inc. v. NRDC. The court reasoned that agencies employ scientists, engineers, economists who possess deep subject matter knowledge that generalist judges do not. Therefore, when a law had a gap or an ambiguity, the agency's reasonable interpretation should stand. This became the bedrock of the modern American regulatory state. This is a fundamental transfer of power from the executive to the judiciary. We could now see a patchwork of conflicting rulings across the country. This new era of judicial oversight introduces systemic friction and risk, where there was once relative stability. Why this legal shift matters for global trade. Global trade is not simply about ships crossing oceans. It is a complex web of rules, standards, agreements. The end of Chevron deference directly impacts this web because American agencies write many of the rules that shape it. Safety standards for imported toys. Privacy requirements for cross-border data flows. These regulations are the invisible architecture of commerce. When rulemaking becomes slow, unpredictable, and subject to endless legal challenges, the entire structure begins to wobble. This creates a chain reaction that will be felt far beyond America's borders. The first and most obvious effect is delay. Agencies will become more cautious. Fearing that their rules will be struck down in court, they will likely undertake a much slower, more painstaking process of justification, or avoid tackling complex new issues altogether. Consider the fast-moving field of artificial intelligence. An agency might want to issue rules on the export of sensitive AI models. This hesitation creates a regulatory vacuum. Other nations, like the European Union, China, will rush to fill it. This leads to the second effect, fragmentation. The EU, with its penchant for comprehensive regulation, this is the Brussels effect. The vast majority of global trade travels by sea, making the rules that govern shipping, ports, and customs clearance absolutely critical. These are areas where expert agencies have long held sway. Treatment of a ship's ballast water to prevent invasive species, classification of a newly invented product for tariff purposes. The end of Chevron deference throws this entire system into question. More disputes, higher costs, significant delays at the border. A simple customs ruling that once took weeks to finalize could now be tied up in court for years, leaving billions of dollars of goods in limbo. Consider the issue of tariffs and customs classifications. A company invents a new smart fabric that can monitor a wearer's vital signs. Is it a textile? Is it a medical device? Is it consumer electronics? Each classification carries a different tariff rate. Previously, U.S. Customs and Border Protection would make a determination based on its expertise. An importer of electric bicycles from Taiwan agency classifies them as motor vehicles, higher tariff instead of bicycles. Now the importer sues in federal court. After a lengthy legal battle, the court rules for the importer. That one win creates a legal precedent. Competitors rush to reclassify their products, forcing customs officials to reassess thousands of shipments, undermining years of environmental progress. From farm to pharmacy, the future of food and drug safety. In the United States, the Food and Drug Administration (FDA) stands as the gatekeeper, setting and enforcing the standards for trillions of dollars in imported goods. The agency's ability to interpret science and apply it to vague laws has been central to its mission, allowing it to respond to new food additives, novel medical devices, unforeseen public health threats. With the demise of the Chevron rule, the FDA's power to act swiftly and decisively is now constrained, which could slow innovation and introduce new risks into the supply chain. For example, when a new lab-grown food ingredient is developed, the law is often silent on how it should be labeled. Is it natural? Does it require a special disclosure? The FDA has historically made these calls based on scientific evidence and its mandate to protect public health. Now any labeling rule it proposes is vulnerable to a protracted legal challenge. This dynamic is particularly acute for pharmaceuticals. Imagine a new class of drug is developed in Germany, offering a breakthrough treatment. Now, it may hesitate, worrying that its chosen methodology could be overturned in court. This could delay the approval of life-saving medicines in the U.S. market. American patients could be left waiting. Two of the most dynamic and contentious areas of global trade are energy and technology. Rules governing carbon emissions are reshaping the economics of heavy industry. Controls on the export of semiconductors and artificial intelligence have become central to national security. U.S. agencies have used their regulatory authority to set policy, often interpreting decades-old laws for 21st-century challenges. The removal of Chevron's legal shield leaves these policies exposed, creating uncertainty for American competitiveness. On the climate front, U.S. agencies have been working to establish rules that would measure and regulate the carbon intensity of imported goods, like steel and aluminum. That aligns with the EU's Carbon Border Adjustment Mechanism, CBAM, and aims to prevent American industries from being disadvantaged. But without Chevron, any such rule is a prime target for litigation. Opponents will argue trade laws don't explicitly grant agencies the power to create what is, in effect, a climate-related tariff. Consider a Louisiana chemical manufacturer. When the EPA's proposed import standard is blocked by a federal court, the playing field changes. In the technology sector, the stakes are even higher. The Commerce Department uses export controls to restrict China's access to advanced semiconductors. Those rules rely on the agency's interpretation of authority in the name of national security. A tech company could challenge a restriction in court, arguing overreach. A judge could narrow the rule, creating a loophole that lets sensitive tech flow to competitors. A world of reactions. How other nations may respond. The United States does not operate in a vacuum. Its legal and regulatory shifts send powerful signals to the rest of the world. As America's rulemaking process becomes slower and more fractured, other global powers will not simply wait for the dust to settle. This will likely lead to a more fragmented global trading system, European Union emerging as a major standard setter, China emerging as a major standard setter. The European Union is poised to be the primary beneficiary of this shift. For years, the EU has championed deep and comprehensive regulation. Now, with the US system mired in legal uncertainty, the Brussels effect will intensify. A car manufacturer in Japan, a software developer in India will find it more efficient to design for the EU's rules on emissions, privacy, safety. This makes the EU the de facto global regulator in many sectors, increasing its geopolitical influence and giving its companies an advantage. A world increasingly divided into three zones: North America, the European Union, China. China will likely pursue a different strategy. Beijing can offer long-term stability and predictability. For companies building complex supply chains for electric vehicle batteries, solar panels, state-directed rules can be more attractive than an unpredictable American market, turning what was once the center of the global trading system into just one of several competing hubs. Winners, losers, the new landscape of risk. Every major economic shift creates a new set of winners and losers, and the end of the Chevron doctrine is no different. The new landscape will favor those with the resources to navigate complexity and punish those who rely on simplicity and predictability. In the short term, the most obvious winners are lawyers, lobbyists. A system where every major rule is decided in court generates immense legal work. Large corporations will also have an advantage: deep pockets, sophisticated legal teams. They can challenge regulations they dislike, shop for favorable court jurisdictions, manage the risk of a fragmented regulatory environment. The losers, conversely, will be small enterprises, medium-sized enterprises. A small business that exports artisanal cheese, handcrafted furniture does not have a team of lawyers on retainer. It thrives on clear rules, stable rules, uniform rules. Faced with a patchwork of conflicting court rulings or a 5-year legal battle over a labeling requirement, many will simply retreat from the global marketplace. This stifles innovation, reduces consumer choice, concentrates economic power in the hands of the largest players. Consumers may also lose out: price volatility, reduced access to innovative products from smaller global producers. In North Carolina, a small furniture maker who sources a unique, sustainable wood from Brazil suddenly finds her shipments held at the port. A new interpretation of the Lacey Act, which bans illegally sourced timber, is being challenged in court, and customs officials are unsure how to proceed. Her business grinds to a halt. Meanwhile, a large, multinational furniture giant reroutes its shipments and barely misses a beat. Conclusion: the path forward in a less certain world. The end of the Chevron doctrine is not a distant, abstract legal event. It is a tectonic shift that has set the global trading system on a new and uncertain course. The era of fast, expert-led regulation in the United States is over, replaced by a slower, more contentious, court-driven process. This will inject friction into global supply chains, create a new landscape of winners and losers, empower other regulatory powers like the European Union. Both businesses and consumers must learn to navigate this new world. Stability and predictability are now premium commodities in global trade. To navigate this future, there are 3 critical signals to watch. First, monitor legislative action from the U.S. Congress. Second, follow key court cases. Third, observe global alignment. For businesses, especially smaller ones, the focus must be on building resilience, diversifying supply chains where possible, using trade associations to stay informed. For consumers, prepare for potential price volatility. Pay closer attention to brands transparent about their supply chains. The world has not stopped turning, but the rules of the road have changed. The balance between expertise and judicial review, between speed and deliberation. The previous system may have given agencies too much power. The new one risks paralysis and chaos. For the rest of the world, the message is clear. The American-led regulatory order is no longer the only game in town. The future of global trade will be more complex, more contested, and defined by a competition of rules. Navigating it will require more vigilance and strategic foresight than ever before.